Welcome back to the final session of the first week of the Academy of European Law for the first of our two distinguished lecturers in the EU law course. And the first lecture will be given by Professor Deirdre Curtin, who many of you will know because she's a colleague here at the EY. She's a professor of European law in the law department, where she's been since 2016. I arrived in 2017, so we've now been colleagues for a long time. And Deirdre has given selflessly to the EY. She was head of department during the difficult COVID years, and she stepped down as head of department. I took over, and she then agreed, remarkably, to become, what's it called, Dean of Students, Dean of Graduate Studies. Dean of Graduate Studies, which is the overall responsibility for the researchers at the UI. And Deirdre just stepped down from that role earlier this year. So Gráinne and I thought, oh good, she'll have plenty of time. She can write a lecture for the Academy of European Law. And again, remarkably, she agreed. So many of you will know Deirdre's writings because she writes extremely broadly across constitutional law and EU administrative law, issues like transparency, agencies, executive power, and so on. So her writings are extremely well known. She's had a very distinguished career, starting as a referendeur at the European Court of Justice, and then moving to the University of Utrecht, and then to the University of Amsterdam, where she was before coming to the EY, where she was founding director of the Amsterdam Centre of European Law and Governance. In acknowledgement of her recognition in the field, Deirdre has received honorary doctorates from University College Dublin and from the University of Copenhagen, and she is a member of the Royal Netherlands Academy of Arts and Science and the Royal Irish Academy. So this gives you a taste of the recognition that she's received. So we're really delighted and privileged to have Deirdre giving the first distinguished lecture today, and the title of her lecture is The Political Stakes in the Technology of EU Security Governance. So thank you so much, Deirdre, and the floor is now yours.
Thank you very much, Joanne, for those very kind introductory remarks. So good afternoon. It's hot today in Florence, and on top of that, this is what we call in Ireland the graveyard slot, which is after lunch. So I hope I can keep you with me as I give this invited lecture this afternoon. My thanks to the organisers for inviting me. When one accepts a year or more or less in advance, one imagines a perfect world in the future with plenty of research time and thinking space for a new take on a salient and fast evolving subject. I won't say anything on how exactly that worked out. In any event, I have enjoyed the process of reading, thinking, and writing my lecture, even if it panned out a bit different in practice. And even if perhaps inevitably I end up raising more questions than I answer and provide food for thought for several research agendas, including my own. My thanks straight away to two wonderful doctoral researchers I am lucky enough to supervise, Matheus de Correa Carvalho, who's online, for working on the slides that you will see in a moment, and to Ludovine Stewart for research assistance on the substance and comments on the draft. So, as the title of my lecture implies, the language of the technical and technology is used as an artifact of hiding. What is hidden is, put simply, the fact that professionals of one kind or another are taking decisions with political stakes and not the politicians. These include, for example, law enforcement and border guards and data professionals, the machine of migration, as it has long been called. They also include, although that is beyond the scope of what I will deal with today, air carriers who carry out rigorous migration control, rejecting thousands of would-be asylum seekers every year. Social sorting of migrants and travellers based on data stored in information systems is at the centre of border controls and migration management in Europe. It has become a vital part of the supranational political process through which borders are constructed, and insiders and outsiders delineated. It's a vital part as well of how power works and is transformed in construction and in daily practices of everyday life. The world of security and migration governance is largely depoliticised, at least in terms of actual everyday implementation. Depoliticisation can be defined as a political process enacted through practices with different logics of action. It's a deliberate strategy, political and bureaucratic. Depoliticisation is, however, a contested concept, and various waves of it have come to the fore within political science and now also in international law, in understanding it as a process and part of wider governance practices. These two scholars, written in very different timeframes and contexts, they even speak of hating politics, both in the national and international contexts. Clearly, it's not a new phenomenon, but the point is that it has intensified with technological advancement. For me, it's not so much about hating politics, but about seeing the political in the technical and the technology being used, and understanding how and where to contest that. Politics is not exactly everywhere, but everything can become political under certain circumstances. It's an ongoing process that may jump arenas and even professional contexts. Now, this may happen in more of a creeping way, that is not visible or only barely. This has been vividly referred to in the literature as the politics of creep by Leysa and Ugolini some years ago. My focus today is specifically on migration governance and border security in and by the European Union more generally. The reason why is that this is a meta field with important logics of action developing over time and that I hope to draw out and bring together. And it's also because a strong rhetoric of depoliticisation exists in migration and security governance. In the EU, it is precisely combined with advanced systems of technology, including interconnected databases, accessible to many kinds of actors. One overarching theme in this area is processes of hiding information as part of depoliticisation, even when the claim is transparency, access to information. So this is quite paradoxical. Hiding is wide as a concept. It implies concealment, intention, and deliberation. It may involve secrecy, but also obfuscation or dissimulation. So what is important to understand about secrecy, and here I'm focusing on the quote rather than the example of Frontex yet, it's less about hiding per se and more about the way in which secrecy structures social relations, regulates communication, and distributes political power. So the idea is that secrecy is actively constructed in the management also of internal information. And the example I'm going to start my lecture with is Frontex, because I think it gives a bird's eye view of these issues. So my example is Frontex, which is, I think most of you will know, it's the EU Border Control Agency. I'm sure you've all read about it in newspapers and on social media in recent years. It's a relatively young EU agency established in 2011. It's a powerful institution that has known a remarkable evolution from a border control agency to what is now widely considered to be a security agency. But, and this is the point, it is remarkably difficult for outsiders to get the information they need in order to challenge its activities and hold it to account for illegal or problematic actions. And several routes have already been tried in the EU context. So it's both the European Ombudsman and then also with the European courts, but so far with very limited successes. And this has to do partially with the wording of outdated legal regulations and procedures and the way they're being interpreted, but also with the available information or evidence and how that is being viewed and accepted. Now, court cases are procedurally relatively contained arenas for the resolution of legal questions. Public hearings in the media and parliaments are much less constrained. Public inquiries aim to bring out inter alia security issues characterised by secrecy into the public domain. So there was a series of public hearings organised by a new Frontex security working group, which was established within the European Parliament in the aftermath of pushback revelations. But it was only very partially successful, even when there are, what are called hard material facts in the form of videos, etc., to show illegal action. So in 2019, media reports, and in particular investigative journalists, including Bellingcat, claimed that Frontex had knowledge of, and in some cases was directly involved in, illegal pushbacks of would-be refugees in Greek territorial waters during something known as Joint Operations Poseidon. A huge amount of work was involved in tracking by the non-governmental organisations and investigative journalists what exactly had happened. During the public hearings, investigative journalists mobilised what is known as material witnesses and devices to expose those pushbacks into the sea of refugees. And this included various objects like videos, images, geolocation data to provide evidence. This evidence was challenged by witnesses on behalf of Frontex, who had control over the presentation and registration of information in Frontex databases. And there is, I don't want to get too technical about this, or I will certainly lose you, the so-called serious incident reporting mechanism. It was designed within Frontex to enhance the transparency of its operations by Frontex, and the claim is that instead it was used to hide pushbacks by selectively reporting information about them. Now, various scholars in other disciplines, including STS and SPS, they explore how non-knowledge results from omissions, errors, and deliberate failures in the processing and sharing of data about migration. So an extraordinary part of this particular secrecy controversy was the fact that an earlier OLAF report, and OLAF is the anti-fraud organisation within the European Union, against Frontex, they had found illegal pushbacks, but their report was classified as secret and was not revealed even to the parliamentarians. Now, OLAF, I'm not quite sure if it's the next slide or not. Will we see? Yes. OLAF fraud investigators took 129 pages to document the involvement of Frontex in the illegal activities of the Greek border guards. They reviewed private emails, WhatsApp messages from the former head of Frontex and his team. They interviewed witnesses, they seized documents and videos. The only reason that we know any of this now is that leaking of this EU-level fraud report via a few newspapers, German in particular, meant that large bits of it came into the public domain. And as a result, the Leggeri, who was the head of Frontex, had to resign in the face of hard evidence and the evidence that there was, in fact, a cover-up by Frontex. If that report hadn't been leaked, then that would not have been known. So I believe this subject will come back for you next week in the course by Joyce de Koning and Violeta Morena-Lex when it comes to litigation and the responsibility of actors, shared or otherwise, for human rights violations. But what we're seeing is that even when investigative journalists and civil society organisations have very material facts and evidence and significant information that has been brought into the public domain, Frontex can manipulate the information under their control to mislead and obfuscate. And the same thinking applies to, this is an example, but it applies to other agencies, other databases, similar governance structures, also in other arenas, including asylum and refugee laws. And it concerns erstwhile governmental functions to screen, control, detain, and deport migrants. And information control like this impacts negatively the rule of law and the fundamental rights of individuals, both citizens and non-citizens. This is not, however, a lecture about Frontex, but about the wider canvas of more hidden logics in the supranational context and how they have developed over time. So I'll give you now a brief roadmap of my lecture. We've had point one, and the core of it is what I call the three key political logics shaping tech governance in EU border control: the logic of latency, the logic of total vision, and the logic of hybridity. I'll speak briefly about the logics of the AI Act, and if there's time, also the use of the concept of national security in this context in order to further avoid accountability, and I'll draw some conclusions. So let me start with the three key political logics, and with the first one, which should come up now. So this is what the logic of latency, of latent development, of something that is hidden within the technological imperatives and later comes out. And we see this quite clearly with regard to the Schengen Agreement. Some or many of you will know the Schengen Agreement was originally signed way back 1985 with only 5 member states agreeing to abolish internal border controls. It was outside of the EU treaty framework because there was no unilateral and unanimous agreement within. It was later, of course, brought back in. But part of the Schengen Agreement was that there would be harmonised control practices at the new common external border, a common visa policy, and particularly the creation of the Schengen Information System. And the Schengen Information System is used by border guards, police, customs, visa, and judicial authorities throughout the Schengen area. It contains information, alerts on persons who have may been involved in a serious crime or may not have the right to enter or stay in the EU, and a lot of other information as well. Alerts, just this is very briefly, are entered into the system by national authorities, and when the first Schengen Information System was developed as an intergovernmental project led by France, and it became operational in 1995. And in 1995, it was already considered technologically obsolete. And in 1996, the political decision was taken to create a second generation Schengen Information System. And this took an awfully long time, as you will see, to actually come into being. But from the very early days, the Council and the Commission regarded this as a future-orientated tool with built-in flexibilities for adaptation as technology develops. And the Commission was very explicit about this, and I quote from the time: "The IT solution should be easily adaptable to incorporate new fields or categories of data. It should be possible to continue developing the technical solution while progressively adding new functions." In other words, the latent development approach was explicitly built into the system without there ever being significant pushback against increasing surveillance and control capacities for state authorities that come with it. And this is what it was eventually. It actually the first Schengen information system remained in operation until May 2013, and it was replaced then by the second Schengen information system, SIS2 as it's known, and it was ready for upgrades, expansions, and the implementation of functionalities at later points in time. So latency, obviously includes the idea that there are dormant functionalities in a system and that can be used for later upgrades, and that there can also be deactivated features that can be activated at a later point in time. So basically, it's a future-orientated, preemptive way of designing new or existing technological systems. And the extended delays during the development and design phase greatly helped this result. And so this process or logic of latent development enables the SIS database to evolve from its beginnings well over 30 years ago as a simple tool for information exchange between national level authorities to the fully fledged tool for supranational investigation that it is today. Now, there was some civil society protest or consciousness of this, but as State Watch put it at the time, by the time there is any public or democratic debate on the scope and function of SIS2, the technical requirements will be in place. It will doubtless be a waste not to use them, and the new system will effectively be a fait accompli. And that's indeed what happened. So the experience of adopting, and this is also an important point, SIS2 led directly to the decision to create another EU agency called EU-LISA. And so EU-LISA is the novel actor directly involved in shaping the further evolution of not only the SIS and its operational management, but also all the other EU internal security databases. And the creation of EU-LISA in 2011 coincided with a political agenda to use, by then, big data IT systems in the area of freedom, security and justice, and to delegate their implementation to this agency. Now, the long title already tells you a bit. It's the European Agency for the Operational Management of Large-Scale IT Systems in the area of freedom, security and justice. And obviously that doesn't sound very political or significant. And any interviews, as those of you who have done them with officials from EU-LISA, invariably begins with their saying the equivalent of, "We don't do politics." It's the classic statement of bureaucracies and international organizations more generally. So the predominant narrative surrounding the creation of this novel agency is one of technical expertise and technocracy. Its power was to be technical, and it presents itself as having a role of only technical support for the implementation of area of freedom, security and justice policy by managing these large-scale IT systems. In practice, it is not just an IT system in charge of maintenance and repair, but it's an EU agency that ensures many things. And it's a vessel into which later new possibilities, powers could and were poured. And it was also a way of not giving this power to the Commission, as it would have meant boosting the Commission resources and institutional power over the politically sensitive agenda of migration and borders. By giving this power to EU-LISA and not the Commission, the feeling was the power was more hidden away and less visible or easy to get information on. Its task is to continuously align the capabilities of technology with the evolving needs of the Member States, and so the possibility for latent development was built in from the start. So let me move to the second logic, which is what is called the logic, or what I have called the logic of total vision. You could also say the logic of eliminating the technological blind spots. So first of all, what was the problem? Well, according to the Commission, The existing border framework does not recognise connections between different pieces of registered information, leading to blind spots and incomplete pictures for competent authorities. So this led to a large-scale, what is known, interoperability project, which was to be developed by AEL, the agency, and then it was adopted in a legal framework in 2019. It has been described as a techno-political project with the aim of fostering further integration and designed precisely to overcome the blind spots mentioned by the Commission and contribute to better identification of people on the move. And interoperability as a concept captures the possibility of making different technologies work together and communicate in the field of internal security. I'm not going to get into the technical details of that, so we see that here the predominant narrative is one, again, of technical expertise and technocracy, and digital transformation is not discussed. It's framed as something that is inevitable, unidirectional, and urgently needed. As one AEL official put it, and I quote, "We are the people who materialise the needs of the European citizens. We are the people who make their concerns or their wishes reality through technology." End of quote. So it presents itself as a harbinger of compulsory change and its activities as a legitimate way of bringing about transformations. And its relative institutional autonomy and latent space has been used, in fact, to construct an exceptional experimental space that it fills with its own visions and transformations. And it is, as I put in the slide, deeply solutionist in proposing future fixes, in a sense, to fundamental social and political problems. And interoperability is one of the key ways, and biometrics and the joining up of various forms of that also. So I'll give you one example and then I'll move on to my final logic, which is about the role of private companies. So interoperability is quite a technically complex subject, but one aspect of the various databases that the new regulations in 2019 set up has to do with ATIAS, which is the European Travel Information and Authorization System. And this is a good example of how agencies and big data and AEL technical operationalization overlap and attempt to overcome silos, even though the subject matter is definitely political. So long out, I've already read it out to you, the European Travel Information and Authorization System will grant travel authorizations to third country and non-EU travellers once it is launched. Now, finally, it appears to be in 2026. It has been under preparation and under wraps in terms of technical and design details for almost a decade. It will be run by Frontex, but AEL does the technical management. So ATIAS travel authorizations are envisaged as a type of light visa and will be based on automated risk assessments as well as the social media scraping of migrants and asylum seekers. These automated risk assessments will be carried out by a profiling algorithm called screening rules in the wording of the regulation on ATIAS. And it remains an open question whether AI will be used and how in ATIAS screening rules and their underlying profiling algorithms. And as Njovi Vavula, who's a professor in Luxembourg, has put it, recourse, and it's on the slide, recourse to the term algorithm may be seen as either a means of avoiding the loaded term of AI or as leaving this issue open for introducing AI in the future. So here again, we see the possibility for latent development or the politics of creep, as other authors put it. So the ATS regulation, and this is the point, leaves considerable discretion to EU-LISA on how the algorithm will enable profiling by comparing special risk indicators with data in the application file. And an EU-LISA report already from 2020 indicated that ATS can employ AI tools in several different ways, and this is very much in line with also previous work that it commissioned and was prepared for the Commission. So the potential use of AI in ATS risk assessment is hidden into the different technical specifications of the systems and is contemplated quite actively to augment it. How this in fact is to be done by EU-LISA and with what software specifics is non-public and is kept completely secret on grounds of public security. And here we come back to Frontex and the steering way it challenges the politics around its own information. And it continues to actively challenge the politics around the use of the term AI and in effect to deny its use even in complaints brought by non-governmental organisations or researchers seeking access to some more information to know how this construction is going on. For example, when a group of researchers at the Université Libre de Bruxelles sought public access from Frontex on the details of ATS risk assessment algorithm, Frontex insisted that it would be more appropriate to talk about filtering queries than algorithms, and responded that no sophisticated analysis methods or any form of AI is involved in the risk assessment. That was a few years ago now, but the explicit use of AI seems much more anticipated now in this context. So this is a developing area. So now I move to the third and final logic that I will have time to deal with in the context of this lecture, and this is the political logic of what I call hybridity. And it's a logic that intersects with the other two, and if anything, with the advent of AI and the AI Act, it has become even more important. So several scholars and some critical non-governmental organizations have highlighted a new market and industry for security technologies in Europe over the course of the past 2 decades. And this industry has come into existence step by step thanks to research and development funding of security-related products by the European Commission. The practice of funding civil security technology and development, and even in some instances military innovation through its research funding programs, has been very largely hidden from public view. And this has been and still is being done through the creation of hybrid public-private consortia that involve the governments of the member states, third countries, research institutions, and the private sectors. And migration governance has always been a site of intertwinement between public needs and private interests. So in Europe, both law and political science scholars have signalled the emergence of out-and-out migration markets in the realm of European border and asylum governance. And the increasing algorithmization of border control has turned such hybridity into a path dependency of EU agencies such as Frontex and EU-LISA, tying them into often large private vendors providing and maintaining state-of-the-art AI-driven technology. So I will give 3 examples, each of which highlight different types and arenas of hybridity that are largely unknown and devoid, on the whole, of any kind of accountability. The first example concerns Eurodrones and Frontex. Oh yeah, there's the three examples. Eurodrones and Frontex, then the ties between EU research funding and AU LISA and Frontex as well, and then a more legal AI lie detector technology and the Horizon programme, which was also challenged before the European Court. So first of all, Eurodrones. European research funding entered the European drone race, especially after what was known as FP7 in the context of Horizon 2020. That's the European research funding, it's very substantial funds. And empirical research that has already been done has shown that defence companies played a large role in the process by which drone research entered the security domain. A number of NGOs tried to raise awareness about the use of EU research funds for drone research, most influentially Statewatch, because hundreds of millions of euros of EU research funds have already been spent on drone projects, and some of these projects have dual-use technology. And dual-use, as many of you will know, is a technology that can be used both for civilian purposes and for military purposes, which obviously raises many interesting questions regarding the scope of EU law. And Statewatch's report on this triggered a debate at the European Parliament, but that was it. The reality is that the political momentum is, in fact, to develop an industry-military complex in Europe that is currently being developed much further. And innovation hybrids are then put at the service of European security, including Frontex. So back to Frontex, as we see. We don't seem to get away from it too much in this lecture. EU border policy is increasingly geared towards the use of advanced technology for the purposes of surveillance, particularly through the Eurosur project. And Frontex's interest in drones and other forms of aerial surveillance stems from its high-tech vision of border control. It routinely participates in the Commission's workshops and conferences on drones, cooperates with the European Defence Agency, and is frequently involved in Commission-funded security research projects. Obviously, cooperation between Frontex and all of this is shrouded in secrecy, but it appears to have focused on the civil-military synergies in border management, particularly maritime surveillance. The drones are being used, we only know, through access to documents cases, but Frontex steadfastly refuses to give any access to documents or information, not even investigation reports when there's been a crash of a Frontex drones. And the private contractors that are involved, that have supplied the drones, they are consulted by Frontex about the request for access documents, and they claim their commercial interest, and then that's it. And Frontex also argues that disclosing the document would affect its current and future ability to negotiate contracts of a similar kind. And it relies on a wide margin of discretion and maintains that disclosing information could pose a risk to the public interest as regards public security. And the European Ombudsman, because there have been a number of cases, basically agrees with Frontex and not the researchers and NGOs, and sort of denies that there is a wider public interest over the public interest in keeping it secret to do with public security. Undoubtedly, that has something to do with the rather technical and very dated access to documents regulation, which is sort of the legal basis of doing all of that. It's more than 20 years old, and it's ill-adapted to the contemporary governance realities. Let me move now back to AU-LISA, because what we discover is that actually AU-LISA plays an active role within EU research funding itself. And I think this is quite a remarkable development, for an agency that is supposedly purely technical, because it's actually involved in steering the technology development that is being funded by the European Union. So this is obviously much more than a passive involvement in observing the technology being developed, but implies an active steering role vis-à-vis both the industry and EU research funding itself. And in 2021, DG Home and AU-LISA agreed terms of reference, that's what's before you here, that basically established EU-LISA's capacity to shape EU research programmes along the lines of their identified requirements for EU internal security databases. And this agreement with the Commission includes the timely identification, development and deployment of new technologies and non-technological solutions in basic and applied funding under Horizon 2020 research funding framework. So the role for AU-LISA is for it to define what the techno-scientific gaps are, for example in the Schengen, but also in other databases, and it then sets the requirement for solutions to be researched with EU funding. And it enjoys the power to invisibly ensure that research activities that are considered capable of addressing these gaps are actually the ones that are being funded. So this is obviously quite a far-reaching situation that goes beyond its constituent act and can be considered part of its own latent development as an institution. It's unknown whether this was anticipated when it was established just a decade earlier, or this is something that has developed over time when it saw various windows of opportunities. And actually, Frontex also has a parallel agreement with the Commission to steer research and innovation funding when it comes to border security. So what this example, in my view, shows of both AU-LISA and Frontex involvement in research funding is that the stage of technology development, thanks to EU research funding, really matters. And that also new and highly controversial technologies might be developed in this context, and then they're subsequently applied by one or more agencies. As my final point then on all of this, I go to inside this process of development and experimentation, or at least I try to reveal the limits of visibility as established by the Luxembourg court in some relevant case law. So this is my last example on the logic of hybridity, and it relates to AI lie detector technology for automated border control security. It was developed for the EU Horizon 2020 funded iBorder Control pilot project. And again, this highlights the lack of visibility and accountability at this early stage trajectory. So lie detection technologies entailing emotion recognition, they were tested in various countries, Hungary, Latvia and Greece, in this project, and it combined several technologies in one system, including biometric verification, deception detection, document authentication and risk assessment. It attracted heavy criticism for its lack of accuracy and thus reliability. The activist and politician Patrick Breyer, he requested access to the documentation of the Horizon project to the European Research Executive Agency, the REA as it's known, and in early 2019 some access was granted, denying access to the rest, and the refusal was based on the commercial interest exception to the right of access to public documents under Article 4, Paragraph 2 of the Access Regulation. Now, this went to the court. He brought it to the court in Luxembourg. And basically, the court found that while the legal framework for the dissemination of research outcomes from Horizon 2020 projects ensures a high level of protection for fundamental rights, it does not imply that these rights have been violated, and there's no overriding public interest in disclosing the documents. And in this particular case, the fact that the I-Border Control project was merely a research project under development, the sole purpose of which was to test technologies, crucially tipped the scales against mandating broader opening of the technical documentation about the algorithmic system. So this restrictive approach by the Court of Justice in the Breyer case runs the risk of leaving crucial AI-related technical information about the algorithmic system out of scope. More specifically, information about its technical configuration, such as its design, its accuracy, its potential for discrimination, and the steps taken to address these risks have all been kept under wraps. And taken together with other case law, the message that the court hammers home is that applicants need to go to great lengths to demonstrate that transparency reasons are really pressing. But this means that the bar is set too high for the vast majority of applicants to access some informational components of AI systems. As AI development is often outsourced, private contractors may and do keep their AI systems opaque to bolster, in accordance with existing legal frameworks, their ongoing competitive advantage over other firms. And that motive then of their commercial interest is imported into public governance. Okay, I'm keeping an eye on the time. So the secret development and use of AI by the agencies using systems developed by private parties ends up thwarting public values and normative foundations such as public accountability and transparency. Now, this is a point that I have specifically developed with my co-author, Dr. Tommaso Fia, in forthcoming work specifically on AI secrecy and its domination by private providers, even in the core of public governance. And the AI Act, in fact, builds on the assumption that migration, asylum and border control management AI systems are already being used inter alia by union institutions, bodies, offices or agencies, but then it does everything it can to make sure that they are excluded from the scope of the AI Act and the scope of the obligations on transparency that are laid down in the AI Act. So, for example, so the logics I've talked about, I'm just going to very briefly refer to the AI Act in this context, but this shows that it doesn't apply if national security is involved, and the important words there are regardless of the type of entity entrusted by the member states with carrying out tasks in relation to those competence. So that's actually seen as potentially as a widening of the exception of national security from the terms of the treaty and also from the existing case law of the Court of Justice in Quadrature du Net. I'm not going to, this is very small, don't worry, but this just shows, this is Article 5. It basically just shows in what ways the assumption is there that, in fact, what these agencies are doing in this area falls within the scope of the AI Act before it's actually excluded to a large extent. Also specifically mentioning ATIAs. So there is a significant grace period given to before compliance with the provisions of the AI Act. And this is brought about actually by member states trying to avoid oversight and accountability. All right, I'm coming to the end. You will be relieved to hear. I will just draw to a conclusion now. So, as Hegel observed so stepping back, Elements of the Philosophy of Right, and I quote, "The owl of Minerva takes its flight only when the shades of night are gathering." In today's world, the owl would be taken out by a drone or other military-level dual-use technology that patrols the open skies. Infrastructures of information and security are obdurate, creating path dependencies, routines, and standards that cannot easily be modified. We may need to be brave and discontinue in the long term, or at least have that discussion openly. In any event, we need vigorous institutions of control and oversight, not afraid to impose real limits to official discretion that impact in a fundamental manner the rule of law and fundamental rights protection. So these are my conclusions. I'll leave them up. They are admittedly overbroad and not fleshed out for you, but that would take another full lecture for you. But I mean, obviously, we need to discuss and reflect more on how to reinforce transparency and accountability mechanisms in a variety of areas that are really important here. So it's not only by the EU agencies themselves, but it's also about the role of private actors in that context, and how, in a sense, their position is becoming very dominant in the governance structures. And what I see happening, but again, you know, there is also here at the EUI, there is very interesting research work being done about the responsibilization of private actors in the context of criminal law or other governance, and online content moderation, all of that. There's quite a bit of interesting work going on there. But what I see happening is also what I call, it's a very ugly word, the de-responsibilization of politics and law. And so that's something we need to reflect further on. And, you know, I think this is an important conversation, not only for its own right, but also because of the links that are ongoing in terms of defence integration, and the links to more overtly political discussions now in Europe on defence funding and further, you know, and path dependencies are clear in that context. Unfortunately, I don't have time to develop that further, but I think it's incredibly important also in the context of dual-use technologies that have already been developed, you know, part of which will fall under European law and the other part probably not. So I'm afraid this isn't exactly an optimistic ending, either for the flight path of the Owl of Minerva, nor for any of us. But I hope, at least by highlighting and seeing the important political stakes in the way technology is worked out, is an important first step to unveiling and controlling the hidden processes of European integration. So thank you very much for your attention.